Hello everyone, welcome to Indian Current Affairs podcast channel. Today we are going to discussing some of very important MCQs on Indian polity. So first question is, in which of the following cases can President not bound by the advice of Council of Ministers? So it is asking about discretionary powers of President. First one is appointment of the Prime Minister when no party attains majority after elections to the Lok Sabha. Second one, exercising pocket veto. Third one, a temporary delay of an ordinary legislation. Fourth one, dismissal of the Council of Ministers. So we have to find out which are the discretionary powers of President. So first one is the discretionary power of the President. How? Now take the current election example. So no party individually get majority in Lok Sabha. Then also President calls Modi to form government. So how it is a discretionary power of the President. But after that they need to prove in Lok Sabha majority. They have to prove in Lok Sabha. But first it is a discretionary power of the President to call a person to form the government. So next one is exercising pocket veto. So what is veto? First of all, there are three types of vetoes. In passing bills, last we have to do signature of the President. We have to take signature of the President. So there are three possibilities for President. First one is pocket veto. That means you don't act on that bill. So you keep that one on his table. So you don't take any decision. So then it is called pocket veto. Then there is other one is absolute veto. Absolute veto means he rejected that bill. And third one is suspensive veto. In that one, he again send bill to the parliament. So there are three types: pocket veto and absolute, and next one is suspensive veto. So like that. So it is also one of the discretionary power of the President. A temporary delay of an ordinary legislation. It is also true. So it comes under suspensive veto. And fourth one is dismissal of the Council of Ministers. So it is also discretionary power of the President. When he feels there is no support in Lok Sabha to the current government, he can dismiss the Council of Ministers if they don't have required numbers in Lok Sabha. So next question is, recently electoral bond scheme was struck down by the Supreme Court of India for violating which of the following fundamental rights provided by the Indian Constitution. So Supreme Court recently struck down the electoral bond scheme. They said it is against Article 19. So in Article 19, right to information is also one of the part. But these electoral bonds are anonymous about who are the donors. So that's why Supreme Court struck down the electoral bond scheme. So answer to this question is Article 19. So the right to information is a fundamental right under Article 19 of 1 of the Indian Constitution. So next question is, consider the following statements about the voter verifiable paper audit trail. So VVPAT system. First one, the VVPAT prints the paper slip with the name of the candidate and the election symbol before being deposited into a sealed box. Second one, VVPATs serve as a secondary line of verification and are crucial in ensuring the integrity of the electoral process. Third one, VVPATs with EVMs were used for the first time in by-election from Knoxen Assembly Constituency of Nagaland. And fourth one, EVMs were first used in Paravur Assembly Constituency of Kerala in the year 1982. So all these statements are true. VVPAT prints candidate name and symbol of the party. And next one, so how VVPATs will help in verification process for the voter. So he has some confidence in the voting system, election system. And next one is, it is EVMs, VVPATs are first time used in by-elections of Knoxen constituency in Nagaland, but EVMs are used way before Kerala in 1982. Next question regarding the directive principles of state policy. First one, borrowed from the Irish Constitution, and Irish Constitution bought them from Spanish Constitution. And second one, from Articles 36 to 51 in Part 4 are PPSPs. Article 44 talks about Uniform Civil Code. Fourth one, they are enforceable in a court of law. So which of these following statements are correct? First one, second one, third one are correct, but fourth one is wrong, because directive principles of state policy are not enforceable in court. So directive principles of state policy are positive obligations of the government. So Constitution provides two things. The first one is positive obligations and negative obligations. Negative obligations means state does not do that one, does not do this one, like that. So those are fundamental rights. So under positive obligations, states should do this one, should do that one. Those are directive principles of state policy. So these are not enforceable in court of law. So next question is, so read the following statements. First one, Constitution divided the DPSPs in socialist, Gandhian and liberal intellectual principles. Second one, some directive principles in Constitution are outside of Part 4. So which of the following statements are correct? So statement 2 is correct. Some of directive principles are outside of the Constitution. I mean outside of the Part 4. But Constitution not divide them as socialist, Gandhian and liberal intellectual. They are divided by some constitutional experts. So those are not mentioned in Constitution itself. So like this, constitutional experts divide them as socialist and Gandhian and liberal intellectual principles. So which article comes under which principle is clearly here given. And next one, directive principles outside of Part 4 are Article 335, Article 350A, Article 351. So those are also directive principles, but those are outside of Part 4. So for example, Article 351 discussing about, under this it is duty of union to spread Hindi language. So like that. This is one of the DPSP. So next question is, consider the following statements with regards to private member bills. First one, its introduction in the House requires 1 month's notice. Second one, the government bills can be introduced and discussed on any day, but private members bills can be introduced and discussed only on Fridays. Third one, the last time a private member's bill was passed by both houses was in 1970. And fourth one, 14 private members bills, 5 of which were introduced in Rajya Sabha, have become law so far. So first of all, what is private members bill and government bill? So what is private member bill? If any person from Lok Sabha or Rajya Sabha introduce a bill, but he is not a minister, then those bills are called private member bills. Even though he is from ruling party also, if he is not a minister, then the bill introduced by him is called private members bill. So now consider them. So to pass private member bill, 1 month notice is need to be there. And then next one is only Fridays they can be introduced. And then next one is the last private member bill is so long before 1970. So it was introduced and passed in both the houses. And till now there are 14 private member bills are passed and 5 are introduced in Rajya Sabha, remaining 9 are introduced in Lok Sabha. Next question. Which of the following schedule was added by Article 31B of the Indian Constitution? So 6th schedule, 8th schedule, 9th schedule and 12th schedule. So 31B was added from Amendment 1. So it is 9th schedule. 9th schedule was added through the Article 31B. First Constitutional Amendment added 31B, which says none of the acts placed in the 9th schedule shall become void on the ground that they violate rights under Part 3 and no judicial review is possible. The act placed in the schedule have retrospective effect. But after that, Supreme Court deleted this article. So it is again against the basic structure of the constitution. Supreme Court said review of courts is basic structure of the constitution. That's why it eliminated this article. So next one is read the following statements regarding preamble of constitution. First one, the preamble of the Indian constitution can be used to interpret the provisions of the fundamental rights and directive principles of state policy. Second statement, Indian constitution was the first one to include preamble as part of the constitution. So first statement is correct. To interpret the fundamental rights and directive principles, we can use preamble, but preamble itself don't have any legal binding. And next one, second statement is wrong, because US is the first country to have preamble in its constitution. India is not the first country. So US constitution was the first to have preamble. Next question. First statement. Indian Union is an indestructible union of destructible states. Second statement. President of India can alter the boundaries of a state or change its name on the recommendations of the Council of Ministers headed by Prime Minister. So first statement is correct. India is a indestructible union with destructible states. But if consider the US is indestructible states with indestructible union. Because we can destruct the states, we can bifurcate the states, we can combine the state, we can change the boundaries of states, and or also we can change the name. But it is wrong. It is not possible by just advice of the Prime Minister and its Council of Ministers. It is not possible to change the name or boundaries of the state. It must be passed in Parliament with a simple majority. Then only we can do that one. States can be merged or split by the Parliament, but states have no right to secede. Only Parliament can alter the boundaries of the state or change its name. So next one, not any by executive order. We can't change that one just by executive order. So next question is, first statement, the right to freedom of conscience is an absolute fundamental right and does not come under any exceptions. So next one is, the SC has declared that right to freedom of religion includes the right to convert people from other religions. So some fundamental rights are absolute fundamental rights. So there is no any exceptions to that one. In that one, freedom of conscience is also one. So it is also absolute fundamental right. But second statement is wrong. So freedom of religion not include to convert the people from one religion to another religion. So explanation, the Constitution confers twofold freedom of religion. First one, freedom of conscience, and freedom to profess, practice and propagate. While the first one is an absolute fundamental right, the second one comes under exceptions and can be regulated by the state. As in Revered Father Stainlass versus State of MP has ruled that this fundamental right does not confer freedom to convert others into one's own religion. So next question. A teenager got a bail in the infamous Pune post hit and run case. In this context, consider the following statement. It is about recent current event. So first one, Section 106 of 2 of the Bharatiya Nyaya Sanhita 2023 stipulates a penalty of up to 2 years in jail or fine of 1 lakh rupees for hit and run cases. Second one, the above provision replaced Section 304A of the Indian Penal Code of 1860. So second statement is correct, but first statement is wrong. For hit and run cases, who do accidents and they don't inform the authorities about that one and they just flee from that location, they will face up to 10 years of jail term and also fine. So not 2 years. 2 years is previous section. Now it is replaced. So now it is extended to 10 years. So The recently enacted Bharatiya Nyaya Sanhita introduces stringent penalty for hit and run incidents in India. The law specifies that an accused individual causing a fatal crash and fleeing the scene without reporting to authorities could face imprisonment up to 10 years along with a fine. Section 106(2) of the Bharatiya Nyaya Sanhita 2023 stipulates a penalty of up to 10 years in jail and a fine up to rupees 7 lakh for fleeing an accident spot and failing to report the incident to a police officer or a magistrate. So next question is, Government of India enacted Chief Election Commissioner and other election commissioners appointment conditions of service and terms of office act 2023. In this context, consider the following statements. First one, Article 324 of the Constitution empowers the Parliament to enact law for appointment of Chief Election Commissioner. Second statement, the election commissioners were selected by a 3-member selection committee comprising Prime Minister, Union Home Minister and Leader of Opposition in the Lok Sabha as per the new law. Third one, the appointment commissioners have tenure of 5 years or up to age of 65 years, whichever is earlier. Which of the following statements are correct? All the statements are correct. So these are the important provisions in recent act to select the Chief Election Commissioner. So next question. Which of the following parliamentary privileges are enjoyed by the members of Lok Sabha? First statement. The immunity from being arrested during the session of the parliament is a privilege available only in civil cases and not in criminal cases or preventive detention cases. Second statement. No member is liable to any proceedings in any court for anything said or any vote given by him in the parliament or its committees. Third one, they can refuse to give evidence and appear as a witness in a case pending in a court when parliament is in session. So all these statements are correct. So those are the privileges of the sum of privileges of the Lok Sabha members. So now see the explanation. They cannot be arrested during the session of the parliament and 40 days before the beginning and 40 days after the end of the session. This privilege is available only in civil cases and not in criminal cases or preventive detention cases. So in preventive detention cases also this possibility is not available. So next one is, they have freedom of speech in parliament. No member is liable to any proceedings in any court for anything said or any vote given by him in parliament or its committees. This freedom is subject to the provisions of the Constitution and to the rules and standing orders regulating the procedure of Parliament. They are exempted from jury service. They can refuse to give evidence and appear as a witness in a case pending in a court when Parliament is in session. So next question. Which of the following statements regarding the writ jurisdiction of the Supreme Court of India is incorrect? So first one, the Supreme Court can issue writs for both enforcement of fundamental rights and other purposes. Second one, for issuing writs, the Supreme Court has original jurisdiction in the sense that an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. Third one, the Supreme Court's writ jurisdiction is broader than that of High Courts. So which of the following statements are not correct? First statement and third statements are not correct because Supreme Court can issue writs only under fundamental rights. They can issue other purposes also when only Parliament gives that power to the Supreme Court. Then only they can issue the writs. Here also it is wrong because High Courts have wider jurisdiction than Supreme Court. Because High Courts can issue writs in both fundamental rights and other purposes also. But Supreme Court can only issue under fundamental rights. So next question is, so the Supreme Court is empowered to issue writs including habeas corpus, mandamus, prohibition, quo warranto and certiorari for the enforcement of the fundamental rights of an aggrieved citizen. In this regard, the Supreme Court has original jurisdiction in the sense that an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. However, the writ jurisdiction of the Supreme Court is not exclusive. The Supreme Court can issue writs only for the enforcement of the fundamental rights and not for other purposes. But High Court can give for other purposes also. The High Courts, on the other hand, can issue writs not only for the enforcement of fundamental rights but also for other purposes. Therefore, the writ jurisdiction of the High Court is wider than that of Supreme Court. However, Parliament can confer on the Supreme Court the power to issue writs for other purposes as well. So, next question. Recently, the Supreme Court has struck down reservations for the Maratha community in colleges, higher educational institutions and jobs. In this context, consider the following statements. First statement, it struck down because it breaches 50% ceiling and found no valid ground for the breach. So next one, in Indra Sahni versus Union of India case, SC stated that there should be no reservation in promotions. So which of the following statements are correct? Both the statements are correct. Because Maharashtra government not give proper data why they provide reservation to the Marathas without any economics surveys or without any population surveys or backward surveys. They just breached the 50% ceiling. That was introduced in Indra Sahni case. So that's why Supreme Court struck down that decision. So in the famous Mandal case or Indra Sahni versus Union of India, the scope and extent of Article 16 of 4, which provides for reservation of jobs in favor of backward classes, has been examined thoroughly by the Supreme Court. Though the court has rejected the additional reservation of 10% for poorer sections of the higher caste. At that time, they rejected that one. So it upheld the constitutional validity of 27% reservation for OBCs with certain conditions. So the advanced sections among the OBCs, so creamy layer is introduced here, should be excluded from the list of beneficiaries of the reservation. No reservation in promotions. So promotions also no need to consider the reservation. But at the time there is reservation for promotions also, that will continue up to 5 years. So reservation should be confined to initial appointments only. Any existing reservation in promotions can continue for 5 years only. So up to 1997 from that case. The total reserved quota should not exceed 50% except in some extraordinary situations. This rule should be applied every year. The carry forward rule in case of unfilled backlog vacancies is valid, but it should not violate 50% rule. So next question is, which of the following items are listed in the concurrent list of the 7th schedule of the Indian Constitution? So in 7th schedule there are 3 lists: state list, central list and concurrent list. So which of the following comes under concurrent list we have to find. First one, marriage and divorce. Second one, taxes on the consumption or sale of electricity. Third one, economic and social planning. Fourth one, postal institutions. Fifth one, library and museums. So which of the comes under concurrent list? So marriage and divorce and economic and social planning comes under concurrent list. That means both central government and state government can form rules regarding these issues. If you see them, so marriage and divorce and economic and social planning comes under concurrent list. In remaining given lists comes under state list. So reformatories, institutions of prisons and postal institutions and libraries, museums and taxes on the consumption or sale of electricity, those are comes under state list. The landmark judgment of Keshavananda Bharati case was delivered by a 13-judge constitutional bench. Who among the following was the Chief Justice who headed the bench? So we know of Keshavananda Bharati case. It's a very important case. By that only we get basic structure of the Indian Constitution. So who is the head or CJ at that time? K.K. Matthew, M.H. Beg, S.N. Dwivedi or S.M. Sikri. Answer to this one is SM Sikri. So thank you very much for watching.